carried out.
Bill before us. Grant us clear minds and clear hearts. And as we leave here at the end of this and go about our business, continue to guide and protect us. In Jesus' name we pray. Amen. Are there any apologies for absence?
Chairman, committee members, let me apologize for my extended absence from this committee meeting. As I was reliably misinformed, it would appear that I was no longer a member of this committee. It was only Sunday of this week that a member of this committee brought to my attention that I'm still a member of the committee. I then requested from the clerk a confirmation if I'm still a member of this committee, and it was so confirmed. And so I wanted to be recorded that I was not intentionally absent, as is being recorded over the last couple of meetings.
Chairman, I'm apologizing for Senator Donna Scott Motley. She'll be absent.
All right. And we have an apology from, member Dalrymple. Dalrymple, sorry. All right, so welcome again. You should, in your emails, have gotten minutes for the meeting held on Wednesday, September 4th, and we will take those at this time. Are there any corrections, helpful additions to those minutes? I have one on page 6, where it begins, clause 12. The first sentence, where it reads, the chairman indicated that the clause provided that a data controller should not make a decision based on automation. I'd rather that be changed to based on automated decision making, because automation has a different meaning. And then in the next paragraph, similar sentiments. Second sentence, where it speaks to decision based solely on automated means. I think we should, for precision, just use the phrase automated decision making. If there are no other corrections to the minutes, may I have confirmation? Moved by Member Cuthbert. Second? We have a second as well. Member Fraser-Binns. Are there any matters arising from the minutes?
Good morning, Chair and members. Yes, Chair, there were two matters arising from the minutes of the previous meeting. The first relates to clause 12, and I would kindly invite yourself, Chair, and members to turn to clause 12, and in particular, clause 12, subsection 5, which provides that if the the bill, the bill itself, page 22 in the bill, 22 in the bill itself. Right. So this particular provision provides that if the commissioner is satisfied on the application of a data subject that the controller has failed to comply with a notice, that the commissioner may do one of two things: either order the data controller to reconsider the decision or to take a new decision. I'm now turning to the big book. on page 52 of the bound copy of the comments. Chair and members, we will recall that on the last occasion a recommendation was made for an amendment to clause 12 subsection 5 to remove the word may and replace it with shall, so that the information commissioner would have been bound to either do one of two things: have the data controller reconsider the decision, or have the data controller take a new decision. And the recommendation that was made by the stakeholder was against the background that the individual had a right, the individual here meaning data subject, has the right to require the controller to reconsider the decision or to make a new decision. And if it is that the data subject had that right, then similarly the commissioner should be bound to either allow the decision to be retaken or allow another decision to replace it. However, when we did our research, we found that in most legislation across the world, the wording that was reflected in clause 12 subsection 5 was the same as what we is the same as what we found elsewhere. So for example, Barbados had the same type of legislation which used the word may rather than shall. Cayman had the same type of the same wording in its legislation which used the word may rather than shall. And so it's our recommendation that it may be prudent to leave the information commissioner with some residual discretion as to whether or not he will order the data controller to reconsider the decision or to make a new decision, or perchance there is something else that may be more appropriate. The information commissioner has that discretion so to do. And so we would ask that there be no change to this clause based on the research.
And I apologize for missing the last couple of meetings. So, in essence, you're leaving the discretion in the hands of the commissioner versus legislating it that he must direct. Okay.
That's correct.
All right.
Chair, the other matter arising would fall to clause 13. Members would recall that on the last occasion, a question was raised with respect to clause 13, subsection 5. Clause 13, we recall, deals with the right of the data subject to request a data controller to rectify any inaccuracy that may exist in any data that is within the control of or possession of the data controller, and of which the individual is the data subject. We had robust discussions on this particular clause, and specifically in relation to subsection 5, the question that was raised was whether or not the data subject would have to incur a fee if the data subject wanted to appeal a determination that was made. As it currently states in this clause, there is no fee that is referenced here. However, in clause 76 of the legislation, 76(2)(c), there's a general power for the information commissioner through the minister to make regulations. And so it is possible for there to be a fee imposed at some point in time with respect to appeals if it is that the information commissioner feels that a fee ought properly to be applied. One recommendation is that we make it very clear that where there is an appeal by a data subject in relation to rectification of inaccuracies, that no fees are charged to the data subject at all. That's one recommendation. The other recommendation is that administratively, rather than legislating it, we allow that to be an administrative decision. So rather than stipulating here that there is to be no fees charged where there's an appeal, we allow that to be a decision and an undertaking made by the information commissioner. Since perchance it may be that at a later stage, when we are more mature in our privacy or data protection legislation, and the information commissioner has built up a body of jurisprudence, and we become more mature as data subjects and data controllers, the information commissioner may recognize that there is a need to charge for these type of appeals as a means to weed out frivolous, for example, complaints or frivolous appeals in the circumstances. And one way you can do that is to impose a fee, for example, so persons will consider whether or not they want to appeal. If we stipulate no, that there will be no fees charged, then what will happen is you'll have to, the Information Commissioner, should he or she want to make that recommendation, would have to go one step further and recommend an amendment to the legislation. So it's recommended that we leave it as it is, and that administratively, certainly at the beginning of this particular process, that we indicate that there will be no fees charged for appeals, and leave it as a matter that could be decided by the Information Commission at a later stage, as is currently the situation in the legislation.
Can regulations, you took the example of seeking to weed out frivolity, but you could also have the other extreme where the fees that are set would effectively eliminate an individual or quote-unquote a small man from pursuing an appeal, and it probably would only be left to larger companies who have the resources. Couldn't regulations related to the legislation provide some guidance there so that it is not left solely to the discretion of the Information Commissioner to determine what those fees are?
But aren't we saying in the beginning, though, that there are no fees? In the beginning of the new regime, there would be no fee for appeal.
That's correct, Minister. That in the beginning, that would be something that could be done administratively, that there would be no fees. But there is a general fee-making power that is in the legislation currently, so that the possibility to charge fees does exist. The Information Commissioner can decide that it will not charge any fees in relation to these matters, and so any regulations made with respect to fees would not include fees relating to this type of action.
Through your chair. Let me start by saying that I agree with the point raised by Member Robinson as it relates to persons who will be most affected if they should make an appeal. I have a concern, though, as it relates to that time that we're going to allow for no fees. If it is solely at the discretion of the information officer, then I have a problem with that, unless we stipulate here that time frame that we are going to allow for no fees. I think that is something that we need to put in place to protect, as Member Robinson stated earlier, the small man, because usually those persons are the ones that are generally affected whenever it comes to discrepancies as relates to data, and it's their data. They make up the majority of the population, so it is their data that will be collected more than any other group of persons. So we have to put that protection in place for them.
Can I ask, what is the, and again I apologize if this may have been covered, what is the general funding mechanism to support the work of the Information Commissioner beyond what may come from the General Consolidated Fund? How would the Office of the Information Commissioner be funded and supported?
One way will be from fees that the Information Commission charges for its services. So, for example, if we turn to Clause 4 on page 12 of the bill, so Clause 4 of the bill actually speaks, which is pages 10 to 12, actually speaks to the making of codes, voluntary codes, for example, and that trade associations, for instance, may submit codes of practice to the commissioner for the commissioner to determine whether or not these codes are reflecting good practice. The commissioner is able to charge for those services, for example. So that would be one way that the commissioner, outside of the consolidated funds and call on that fund, can actually raise funds for its services.
I want us just have a little bit of caution here. The implementation of this legislation is going to be costly to a number of persons. And while I understand the need for the commissioner to have discretion over what fees are charged, we have to be careful that you don't have a piece of legislation which in effect just can't be used and is not accessible. Because without the fees for football club, Arnett Gardens, to comply with this is going to be costly. So if you're going to have fees on top of that, then people just not going to comply. So I think we need to, again, it could be in regulations, but I think we need to provide some guidance on this issue so that it's not just large banks or large corporations who have a legal department or can hire somebody can actually comply. Because if I'm a commissioner and I really don't want the hassle of everybody appealing, then I'm just going to set fees which take it out of the reach of most people to appeal. And it shouldn't be left to that person solely to make that determination.
Chair, if I may, though, just to clarify, the general fee-making power that we're referring to under Section 76 is the power that is actually given to the minister, but the minister would be acting after consultation, of course, with the information commissioner. So the discretion really would rest with the minister in the circumstances. So it doesn't change the concern that I'm hearing on the ground, which I just wanted to ensure that we're clear that the residual power to make fees is one that is placed in the minister under Clause 76 of the legislation, of the bill.
Sorry, but just to clarify, so even though the minister is one that has the power to charge the fees, it is still, am I to understand it is still within the discretion of the commissioner to charge those fees? Because the minister will prescribe the fees, but the commissioner will determine whether or not to charge them, or is it that once the fees are prescribed, then the commissioner has to? Okay, because that is not being made clear.
So just for thank you very much, member. Just for clarity, no, it's once the regulations prescribe the fees, there is no discretion that is now given to the information commissioner as to whether or not to charge them. The fees would have been prescribed.
Then, if that's the case, then we would have to look back at Clause 4.9 because it does give that discretion to the commissioner.
So I just want, okay, so I'm going to say it again. So where we look at 4.9, there are two different fee structures in the legislation. The Clause 4, Subsection 9 fee structure is a fee structure which the commissioner has the power to impose. However, the Clause 76 power to impose fees are fees which are imposed by the minister for very specific, a general fee-making power. Where the commissioner has a power to impose fees, it's very specific. And so in that clause, for example, the power is specifically in relation to services which the commissioner provides to the general public.
Member Robinson may have, because then are there going to be some guidelines provided to the commission as to how these fees should be charged, or the range of fees, so that they are not priced at a level that puts them outside of the reach of the regular person, or that invokes more hardship on the regular person, particularly small businesses?
Just a moment, Chair. Right. In response, one of the things that we recognize, usually where there are regulations and they have to impose, and regulations impose fees, there's usually consultation, whether very broad or specific, with the members or persons who are affected. So we would expect that in coming up with the fee structure, but prior to this particular structure being prescribed, the Information Commissioner would consult with the requisite associations in relation to the in relation to the fees and the fee structure. One thing, just to be clear, we're going to look back at 4.9. We're going to look back at 4.9. In Clause 4, Subsection 9, it says the Commissioner may charge us fees. As we're looking at it, we realize it says as prescribed. So these also would require the minister to prescribe the fees here. So the Commissioner would not be at large, even under this one. There's no need to rewrite it.
So there is no power given to the commissioner to charge fees?
No, not on his own or her own.
Save and except he has a discretion to charge a fee. The fees are prescribed by the minister. We get that, but the prescribed fees may or may not be charged as the commissioner determines based on the use of the word may as opposed to shall. Or perhaps CPC can guide us if that is how mandatory provisions are written.
I was just listening to SG. I'm so sorry. So just to make sure that we're clear, even though it says may here, there's no discretion that is being given to the commissioner. Once the fees are prescribed, the commissioner must charge those fees. If it is that we are desirous of giving the commissioner the power to waive fees after fees are prescribed, that is something that we'd have to put specifically in the legislation. Sure. Thank you very much, Chair. We're just clarifying. The SG is going to check because, as currently stated, you wouldn't need a specific power to waive, but the SG is saying that she's going to look at other legislation to see if it is how it is structured, because it could be that you may want to include a specific power of waiver. So that is something that I'll allow the SG to research and then get back to us on.
Madam Chairman, and I'm sorry for going all over the place, and because I missed the last couple of meetings. Take me to the clause which speaks to the accountability of the information commissioner, just in relation to, and that's why I say, I don't know if it was covered, I don't know, but I just, given the discussions we're having, a concern arose just about the, in my mind, about the accountability of this information commissioner. I don't know if it is to Parliament or to, but just take me to that clause so I can satisfy myself about that accountability framework.
All right, so Kadian, before you come in, let me say, I think we're moving into that section now in terms of the obligations of the information commissioner. Last week, I mean, what we talked about was mostly the rights of the data subject, so we're going to move into that section now. All right. So subject to the SG, subject to the clarification, or you're going to?
Yes, thank you, Chairman. So in relation to fees, the only difficulty I have is, although this says the commissioner may charge fees for services provided, we're not really clear what those services would be. So I assume they would be set out in an order. No, I know it just says services provided, so I'm just saying that.
Kadian, the matter is about the charging of fees and the time we'll allow once we have passed this bill into law before we start to charge fees for appeals. Will that be left to the discretion of the minister for the implementation or the implementation of the collection of the fee services? I mean fees for services? Because we would want to encourage persons to appreciate and utilize this act as relates to data, protecting your data. So you do not want it to be, the fees to be inhibitory, you know, so you would want persons to feel comfortable utilizing the provisions of this Data Protection Act. So I wonder, do we have to stipulate, or we just leave it there and put in place something that states that after a year or 2 years we will start to collect fees for services or appeals?
Sorry, if I can just interject there then, because now I'm a little clearer. It's really just one fee. It's just when somebody writes in, it's whether, and the person is asking for access, it would be one fee.
So there's no fee for an appeal then? Is that what you're saying?
No, this fee is only in relation to what's in subsection 8, which is...
Under subsection
to be able to get the data under 8. So it really is just one fee. Under 8, it's really one fee. No, what the committee could consider is whether, as happened with under the Access to Information Act, the kind of persons who may be using this, and whether or not you think there may be an inability to pay, which was the same kind of thought process that went into reproducing documents at a cost. And so in the ATI Act, there is a provision that allows, in relation to reproducing, the fees for reproducing documents, meaning getting photocopies. It says the responsible minister may waive, that's section 12.2, reduce or remit the cost specified in subsection 1 for access to an official document where he is satisfied that such waive or reduction or remission is justifiable. That was done because it was felt that there would be true, you may have a wide cross-section of persons who are trying to get access to documents, but you would also have a certain set of persons who may not be able to afford that cost for the copies. And so this was a facility put in place to allow the minister to take that into account, that someone may truly have a difficulty and they could either waive or remit or reduce the cost. So if you are of the view then that the kind of persons who may be utilizing this provision that also may have some sort of difficulty in being able to pay the fee, then you could consider a provision similar to that in the ATI Act.
Okay, let me say that it's not the intent, I do not believe, of this government to use this entity, to use fees, for this entity to be an entity that charges large fees and, make profits off fees. The regime that we're ushering in, we want it to be available to all Jamaicans. And I think what the law or the act is trying to do is to address those services that may be outside of the ordinary. As you're saying, copying data, or if somebody requests years and years of data, that there may be a fee associated with that. Am I interpreting that correctly?
I have another question while you think about the answer. Is it the Information Commissioner in the first instance who is the sole determinant of the validity of an appeal? So John Brown from JX Road Citizens Association decided to appeal something. Is it the commissioner who determines whether John Brown's appeal is worthy of even being considered, or whether he or she will throw it out?
I think I just want to make sure that we are putting different things in context. I think we're talking about two different things and two different circumstances. So to answer your question, with respect to Clause 13, Clause 13 is a very specific appeal process. And this particular appeal process is a process which is appealing where the data controller has not rectified an inaccuracy. Very, very specific. Where we started off this morning was to suggest that as it is right now, any fees that would be charged here would be charged based on the general fee-making power under Clause 76. That is a power which is resident in the minister. But of course, in the circumstances, the minister would take the advice in determining where the fees would fall here. The general fee-making power would cover fees for different things and different services. What is referenced in Clause 4 are fees which are charged for a very specific service. And it's a very specific service, which is the assessing any processing of personal data for good practice. That is very, very specific under 4.8 and 4.9. And those fees are also prescribed as well there. I'm very specific about that because the comment that was or the suggestion that was put to the committee was whether or not the committee would want to determine different levels of fees under clause 4.9 based on the type of data controllers that would be asking the commissioner for assistance in relation to 4.8. Very, very specific. That is something that the committee could determine it wants to do in the circumstances based on who it is that will be coming to ask for these services. More than that, if we look on page 11, the entities which are more likely to be asking for these types of services are trade associations, for example. Not that it can't be other persons, but trade associations, for example, are persons who will be asking for these types of assistance under 4.9. Not full stop. Where it comes to clause 13, I'm going back to 13 now, 13.5. The Information Commissioner is not at large to determine which appeal it will or will not consider. The legislation is clear that once it is that there is an appeal, the Commissioner then must make an appeal by a data subject. The Commissioner must make a determination as to whether or not he is satisfied that one, the actions taken have been taken by the data controller, or if the actions have not been taken by the data controller, then what he can do next. I still think there is a decision if the committee, the recommendation was from the SG in relation to clause 4, subsection 9, for the committee to determine whether or not it would want to have different categories of fees for different types of data controllers.
But I also thought the SG was saying we don't yet know what those services are going to be or who, so I don't know that we can at this point in time describe those fees. All right.
That would be my recommendation, that we don't, that
Right.
we leave the clause as it is, clause
Okay.
4.9 as it is.
All right. So members, as it relates to clause 12 and 13, the recommendation is for these clauses to remain as is. Do we have the approval of committee members? No dissent, so approved. All right, we will move on to part 3, requirements for data controllers, clause 14.
Thank you very much, Chair. There were no comments on clause 14 in the matrix. However, clause 14 really is an interpretation clause which seeks to explain what registration particulars mean, and that's further defined in clause 16.2, and also to identify or to explain what address of data controllers and data controller representatives really mean. So there were no comments that were raised in relation to that clause, Chair. So we'll move to clause 15. Clause 15 outlines...
1 second, hold on. We'll put clause 14 to the members. If there are no objections, we will accept. No objections.
Thank you, Chair. Clause 15. Clause 15 speaks to one of the requirements for data controllers, and this stipulates that a data controller shall not process personal data unless a data controller is in fact registered. The registration requirement is outlined there, and the comments that we received on this clause were many and varied. The comments ranged from a concern that all data controllers were required to register, and that this particular requirement of registration was both onerous and represented overregulation. Another comment was that credit bureaus ought properly to be exempt from this particular provision, as credit bureaus are already registered under the credit reporting legislation and should be able to rely on that particular process. Also, a concern was raised about the exemption that was given to public registers, and why should public registers be exempt from the requirement for registration, and would be the registrars of public registries. Also, a concern was raised by media houses that data processed for journalism by media houses should not be the subject of registration by media house as a data controller. They should not be required to provide those registration requirements. Chair, you will notice that the ministry would have looked at the comments, chair and members, and we'll start first with the concern raised in relation to the credit reporting legislation. And based on our research, we did not see in any other legislation where credit bureaus were exempt from the requirements of registration under the data protection legislation, and it's not our recommendation in this instance that they ought to be made exempt as well. When we looked at the registration requirements under the credit reporting legislation, we noticed that there were some similarities. So for example, there's a requirement for you to state the address and company information of your credit bureau. But then there are also other requirements that would be under this legislation which would not be reflected there. For instance, you would have to state your data protection officer and the details of your data protection officer, for example. And then you would also have to give a description of the data which is being processed. And so it's our view that the requirements under this legislation are more expansive than the registration requirements under the Credit Reporting Act. And so we would recommend that credit bureaus not be exempt from the provisions of this bill. Similarly, when we assess the concern that was raised with respect to overregulation by requiring registration by all data controllers, we recognize that all EU states prior to the GDPR were required to register. All data controllers, would have been required to register based on the prior directives in the EU. We keep saying, Chair and members, that this will be a new regime, and we believe that the Office of the Information Commissioner ought properly to provide with information as to all persons who are processing personal data, at least in the first instance. It wasn't until the EU's regime was more mature that the GDPR would have removed the requirement essentially for automatic registration. And we are of the view that we should maintain this particular provision as it is, where all data controllers are required to be registered. For this reason, we indicated that it is not only important for oversight, but it also provides the Information Commissioner with information to assist it in the execution of other key functions, such as training, guidance, and directives. With respect to the concern that would have been raised, Chair, as to the exemption of public registries or public registers, again, we're of the view that if it is that you have there's a public registration under this legislation would be superfluous. For us, the establishment of a public registry is guided by legislation which identifies the nature of the data that is collected there, how it is processed, and the means of access. For this reason, the information that would be contained in a public registry and also the legislation that would have guided the establishment of the registry would provide the information that would be required under this legislation. And we felt that there was no need, again, for us to require public registries to also be registered as data controllers under this law. So it's not our so we don't have a challenge with the exemption that's provided to public registries. Chair, the other concern that was...
The offices of members of parliament, would that be regarded as a public registry? We have to take,
Public register is not defined.
No, it's not. No, it's not.
I mean, would that include like a healthcare organization, a hospital that keeps data on patients? What about the court system and case files in a database there?
No, the purpose of in the legislation, given, okay, I'm going to point us to the exemption. So it's 15.2. It depends on what is the sole purpose. The sole purpose essentially must be that you're keeping a registry for no other reason. That is the basis on which you have the exemption, that your processing of data is just to have a registry of information. So if it is that it's used for any other purpose, it wouldn't fall within the class of the exemption.
Isn't that rather ambiguous, though, when you talk about the sole purpose of which is the maintenance of a public register? I mean, any public register is maintained for some other purpose. It's a means to an end. I mean, it seems to me that you can have personal data in public spaces, you know, in public registers which are unprotected. Many of the public bodies that have data on people don't have any modern governance regime applicable to them. They're set up, they may be decades old before computers even became pervasive. So that's one issue. And the other issue is, I mean, if the European Union's guidelines, or whatever they're called, regulations that they've come with, which seem to be becoming more and more the international standard, if they saw fit to change their requirement so that not all data controllers have to register automatically.
She said automatically, but they do have to register, just that it's...
What do you mean?
As long as they're processing data, it's just, I think what I heard Ms. Newton-Smith say, that they moved away from automatic registration after they'd had some experience with their regime. Is that correct?
You mean automatic registration? You mean automatically being required to register?
I'm so sorry. I didn't hear. I'm so
No,
sorry.
in the EU, they had originally in the directives required automatic registration. I'm not sure what that really means, but they're no longer requiring that. Can you just explain the difference?
No problem. In the EU, they would have required all data controllers to register. So that was the requirement. Data controllers are not now required to register as a mandatory requirement anymore. But I just wanted to ensure that we are clear that registration, the fact that you're not required to register under this particular clause doesn't mean you're not required to follow the standards which are in the data protection bill, because you're still going to be required to comply with the standards. As we'll come to see when we look at clause 16 and beyond, the purpose of registration is to provide information as to the data that you're collecting and what you're doing with the data, who you're going to transfer it to. And so where it is that you have a public registry, for example, and that the information that you are collecting and what you're supposed to do with it is already stated usually in the nature of the document that would have created that registry.
I'm not satisfied with that response. I think there's a plethora of public registers or public bodies that collect people's data. Some are governed by modern pieces of legislation, some are governed by no legislation or were set up administratively, and some are governed by legislation that predates privacy issues and the computer age. I don't see why they should be excluded from the requirements of registration and whatever protections that gives citizens. I accept the point that the standards would apply to them, but in monitoring whether or not they're complying with the standards, if they're not registered and aren't required to provide the information that registration necessitates, then it may be less effective. The upholding of the standards and making sure that that is done may be more difficult. So I'm not convinced about that.
I agree with Member Golden that they should not be exempted. Additionally, how would consumers know? How would citizens know who are the entities collecting information about them? Yeah.
Chairman, I have a question for subsection 2. That subsection 1 does not apply to processing of a particular description specified by the minister by order in the Gazette. And I wondered whether you could share with us what, in your minds, would be those particular description that would be exempted.
I'm going to let CPC speak to clause 3, and I'm going to get back to you on to clause 2.
I'm
I was just wanting to observe that if it's a public register, which in its literal meaning it's a register that's open to the public, so the Information Commissioner as well as the public would already be aware of the existence and contents of what's in the register, for what it's worth.
Well, a public register, it's not a defined term. The CPC has interpreted as meaning a register where the information is available to the public.
Well, that would be the literal meaning, yes.
Yeah. But I mean, I was thinking of it as a register maintained by a public body or for a public purpose. I mean, maybe some data is available to the public, maybe not all, I don't, in terms of access. But the fact that it's not a defined term makes it, I think, less precise as to what exactly 3 is dealing with. Yeah. And going back to the other issue, I mean, I know that
Do you want us to just finish on this first?
Sure.
Yeah. Kadian and members. I think the argument is sound in terms of public registry, whether or not the public knows what the data is in there, but this is a new regime that we're starting. You wouldn't want to have unnecessary confusion about who's registered, who is not, and why they're not registered and why they're registered. I don't see any harm in including them, and you can guide me accordingly.
I think the decision will be one as to whether or not we are going to exempt public registries generally, and if we are going to exempt them, then we'd need to have a definition provided as to what it is, and I think we're saying that we don't want to.
Okay, so that would change clause 15, subsection 2 then?
3.
Oh, subsection 3, okay. Okay.
May I ask Mrs. Smith, Ms. Smith, what was the reason behind subsection 3? What was the reason behind inserting subsection 3? Because there must have been a reason why you thought that certain categories should be exempted.
That's what would have been explained by CPC earlier, that when you look at the nature of what public registries are and the literal interpretation of public registries, the type of data that it collects and the information that it keeps and the data subjects that it relates to would have been information that would have been provided, would have been known already to the public, and that information would have been set out in any legislation or document that would have established the registry. And so when you look at the registration particulars in clause 16, subsection 2, a lot of these requirements essentially would have already been met by virtue of having a public registry. And as such, there was no need for us to stipulate that a public registry now needed to be registered in accordance with this legislation because we thought it was superfluous. It doesn't prevent, as I mentioned earlier, that particular registry complying with the standards and the principles that are already laid out in the legislation. But I understand the member and the committee to be saying that given the nature of public registries, the term being undefined, and because it could include registries for which there are no clear documents or any enacted legislation that would outline the nature of the data that is collected, who are the data subjects in a very clear manner, that exempting public registries would not be something that this committee would be minded to do at this time.
All right. Okay, so regarding clause 15, subsection 3, the committee to move that public registries be included for registration. Yeah. Subsection 3. Clause 15, subsection 3 to be deleted. So moved. No objections. We'll move on to clause.
Chair, if I may, I think the member had a question about 15.2 and I had agreed to come back to 15.2 after we had settled clause 15.3. When we considered 15.2 for inclusion, we were thinking of circumstances where, the term would be the little man, for example. So it says it doesn't apply to processing of a particular description specified by the minister being processed in which is unlikely to prejudice rights and freedoms of data subjects. So for instance, if there is a particular group, like a church group for example, and the nature of what it does, you don't anticipate that the processing that it's going to, the data that it collects and the data that it processes will affect citizens' rights. And the minister could, in those circumstances, decide to exempt that particular entity from registration. And that was the purpose for this particular clause.
I wonder though, Chair, and it's sorry, Juliet.
Okay.
It's just a recommendation I have because we all know how people are about information, and I wondered. I take the explanation, but in light of the explanation given, I wondered whether the approach could be different. So instead of by order in the Gazette, whether it could say by resolution. So at least it comes to the Parliament, and we know what is it the minister intends to give the exemption to.
I mean, there might be a plethora of applications for exemption here, you know, because I mean, the requirements of this are fairly burdensome, especially for less formal, less well-endowed organizations. So, I don't know, to kind of clog up parliamentary time with having to approve them. But you can consider that. But I wanted to ask the chairman on that issue.
Couldn't we say, though, when I look at the requirements for registration, they don't look onerous at all. I mean, somebody can tell me otherwise. The name of the, the business or association, the address, the name of the person who is in charge of data. It doesn't look onerous to me, so I don't.
Chair, if I just address the concern raised by Member Golding, I think the power to specify by order would relate to categories. So it's not that individual exemptions would come, it would be the order prescribing what categories would be exempt. So it would be a one-off, or wherever that order has been amended, then it would come back if it's made subject to affirmative resolution pursuant to the recommendation that was proposed.
So a category might be what? Churches? That might be a category?
Or service clubs, for example.
I think we might get into a quagmire there in terms of these exemptions, honestly.
Minister, if I could just ask though, the EU having decided not to require all data controllers to register, that being a current decision based on their experience, I wanted to find out if they could enlighten us as to what was the rationale for the EU moving away from a blanket requirement for registration to one where not all data controllers have to register. What was the reason behind that move, and what criteria are applied in the EU regime that to determine who does not need to register? What is the basis of that decision, or differentiation between those that do and those who do not need to register? What we are going on is that we're relying on a ministerial exemption by way of categories, perhaps, or although it's not, to my mind, very explicit in 15.2 that it's dealing with categories of persons. It speaks about processing of a particular description. That's the language used. The nature of the processing, as opposed to the nature of the data controller. So I'm not comfortable with that explanation at this point. But given that the EU standard is the newest and most becoming the pervasive standard internationally, and they have moved in the direction of not requiring all to register, I think we need to have a good understanding of why they made that move and what criteria they apply in differentiating between those who do and those who don't.
Right. So we can start off by looking at the construct. So one of the things that we would have found in our research was that when the EU would have transitioned to this particular process, they would have still kept a residual requirement for general notification obligations. So even though there is no general mandatory requirement for registration, they kept a residual power in each EU state to be able to require notification where certain activities were being undertaken. So for example, if there is processing of personal data relating to criminal convictions or offenses, for example, that is something that the EU an EU state, could still require a data controller to notify the information commissioner or the supervisory authority about, because it's processing that type of data. And that is one of the regimes that they would have had. One of the things that the EU regime would have done is that because it would have now had a very mature privacy system or privacy jurisprudence, and also a very mature supervisory authority, it replaced a lot of this mandatory sending of information to a supervisory authority with this rigorous requirement for internal processes by the data controller. So that, for instance, the data impact assessment that has to be conducted by the data controller needs to indicate, among other things, if it is that the data controller is processing data which is likely to prejudice the rights and freedoms of the data subject, for example. That's one of the things that they would have done. And so in looking at the shift and the move, it was our assessment that the EU would have been in a position to require data controllers to do notifications because they would have had information already on the majority of data controllers within their states, because that registration requirement was something that was in effect for many, many years. We're of the view that because we are just starting our data protection regime, that the information commissioner ought properly to know who is out there as a data controller and what are the types or categories of data that these particular data controllers are in fact processing, and the purpose for which they're processing the data and where the data would be going.
The EU regime a non-registration regime now? No one has to register any longer?
That's correct. It's a non-registration regime.
But Member Golden, it would seem to me, and I think that's what I heard Ms. Newton-Smith say, that their regime is mature relative to ours, and they have a lot of information, and that their process of making sure that your internal processes are good seems to have been in effect and working, whereas we are entering a new regime.
I mean, I don't think the EU is homogeneous in where they are on this curve. So you have, there are countries in the EU which are really not even fully first world countries yet. Some of the more recent Central and Eastern European states that have joined, and there are possibilities of other states joining who may not have a developed regime at all, and they would then have to comply with this new standard. So I don't know whether the explanation is to do with the level of maturity or how far advanced they are in the practice of processing data in a rights-friendly way, or what. But to me, it's interesting that the trend there has been to move away from registration, and we are enacting new legislation that requires registration.
But how would we begin?
How would we?
We begin this regime if we don't require registration? Yeah.
Well, I guess if we were to have adopted a non-registration model, we would have particular categories of information that require notification. We'd follow what they've done. So if you're processing something that is considered to be sensitive, that would require you to notify the data controller, not the regulator, that you're doing that. But if you're not processing information within any of those prescribed categories, then you wouldn't have to notify, you would just have to comply with the standards.
But in the beginning, though, again, how would the Information Commission know who's out there? It seems to me that it's the requirement for registration at the beginning of this whole regime is more probably to establish who is out there.
Chair, if I
It's
may,
a massive bureaucratic exercise, that's for sure.
But Chair, if I may, I could point the members to the research that we would have conducted. So our research would have been conducted not only in relation to the EU and the GDPR, but in also other states that have data protection regimes. So for example, we found that in privacy laws in Africa and Near East, 18 jurisdictions of the ones we researched required some type of registration process for data controllers. Similarly, when we looked in the LAC region, Latin America, Caribbean, and we extended it to Canada, we found that 6 countries required registration: Argentina, Costa Rica, Colombia, Peru, and Uruguay. And so even though within the EU regime, there is a no registration approach, other regimes actually require registration of data controllers. No, not all. Other regimes require it. That's correct.
Was there any study done to the countries who possibly did not require that initial registration?
So we did find countries that didn't, because as we indicated, it wouldn't be all. So for example, when we looked, and the member Golden would have noted earlier that there are other possibilities that the committee could consider. So for example, if the committee is not minded to have a registration regime, and the committee isn't minded to go fully to a non-registration regime, the committee could determine that there are certain things for which you must give notification, a notification system. So for instance, in Benin, for example, except for accounting, personal and payroll, registration is not required. For example, it's an African country that does not require registration for data controllers. Cote d'Ivoire, for example, has a different approach. It says registration must be done unless it is that you have a data protection officer who is appointed or some other exemption applies. In Israel, for example, databases that fall into specific categories must be registered, and those that do not, you don't have to have registration. So there are various ways that we could establish the registration regime if we wanted to. If we felt that the registration regime as it is right now, requiring all data controllers to register, is onerous, then we could determine it based on categories of information, for example. However, we would caution against it because we are, and this is the thinking, we're a new regime. We would want to start off by requiring all data controllers to register so that the information with respect to who is processing personal data, what are they doing with the personal data, that falls into processing as well, who they're transferring the data to, who are their data protection officers, their representatives, that information can already be collected at the beginning.
Okay, with regards to clause 16, provision of registration particulars, do we have any objection from committee members? No objections to clause 16.
Chair, before we move on though, we were asking for some clarity with respect to the recommendation at clause 15, whether or not the order was going to be made subject to affirmative resolution. I believe that was a recommendation, and we had provided some clarity in relation to that.
The language of the exemption provision in 15.2, where it talks about that subsection 1 that does not apply to processing of a particular description, and focusing on the type of processing that's being done, as opposed to the categories of data controller. Are they one and the same, or is that two different concepts? And if they're different, then what would be the type of processing that would potentially warrant being exempt?
It's not necessarily different because it depends on how you describe it. I mean, the exemption could, for example, speak to processing carried out by a recognized religious institution solely for the purpose of keeping a record of its membership.
It's just that that's a kind of strained interpretation of the words used. I mean, processing of a particular description if that was what we are intending to use as a yardstick, i.e. the type of data controller involved, I think the language ought to focus on that as opposed to talking about processing of a particular description as to, you know, how it's done or so I think if the idea behind this is to allow different categories of entity to be exempted by a minister, then I think you ought to say it. And if you want that to be subject to affirmative resolution, so it has to go to both houses of parliament for approval, you know, so be it.
Chair, however, when we look at the use of the word description, we think that description would need to remain as it is, because description could cover different types of things. It could deal with the category, it could deal with the type of the processing that you're dealing with. If you start to limit it to, for example, a specific category of persons, then it removes the flexibility here that is given to the minister to determine who is likely to be exempt under 2. So that is the reason it would have been left as general as it is, or written as general as it is.
Mm-hmm. I think if you want to have more flexibility, it would be useful to say that it does not apply to data processes of a description specified by the minister or to processing of a description. So you have both categories as possible, since you don't really know what you might want to exempt at this point. But I just think that the wording here is not really ideal for dealing with a regime of exemption that applies to data controllers of a particular category, such as churches or schools or I don't know who else you might want to exempt. Ultimately, it's a drafting issue, and I shouldn't really be delving in it, but it did occur to me that when I was hearing the description of what this provision is designed to try and do, it didn't really seem to me that it was really worded with that in mind.
Sorry, so Member Golden, instead of particular description, you're saying that could be replaced?
I think you could say processing of a particular description or processing by particular categories of persons specified by the minister by order. So the minister could be focused on a type of entity that ought to be exempt or a type of processing that ought to be exempt.
That's fine. That's fine. Chair, we would just want, however, to also point out one of the other comments that was made on clause 15, just for completeness. And the question that was raised was whether or not the Information Commissioner should have a watchdog to ensure that it also is complying essentially with the provisions of the Data Protection Bill. So the concern was one of good governance, and the reference was one of almost indicum. And one of the things that we wanted to point out to the committee was that the Information Commissioner would be subject to the Data Protection Bill essentially as all other bodies. There was a concern that would have been raised, and we'll see it later on, that was raised by another stakeholder, and a recommendation that was put on the table to have an ad hoc privacy commissioner, for example, that would look at concerns that were raised in relation to the Information Commissioner itself. And when we get to that particular clause, Chair and members, we could look at whether or not we'd want to create such an ad hoc commission as well to provide oversight. And I'm just being very clear, it's an ad hoc commission that is provided. It is actually to deal with complaints against the Information Commissioner that it is not following the requirements of the Data Protection Bill. Very, very specific.
If I may, Chairman, just based on something that Mrs. Newton said, because I do recall that at the last meeting I attended, or perhaps the second to last meeting, the issue of the governance of the Information Commissioner was discussed, and regrettably, I was not here when a determination was made. Mm-hmm. But are you talking about a decision that was recommended a recommendation that was made in that regard?
No, and forgive me, the question was actually raised earlier and we did not address the question. So the concern was raised on what was agreed in relation to the governance structure, and it was agreed that we would look at the Integrity Commission structure, essentially where the Information Commissioner would be reporting to another entity above it, like a board. I'm very careful to use the word board because there also was a committee essentially, but it would not be the sole determining entity sole determining person within the office of the Information Commissioner.
Sorry, my apologies. I was out. Is the Information Commissioner a Commissioner of Parliament?
No.
So there would be no scope for parliamentary oversight which currently exists under the Integrity Commission Act? That's what I was alluding to earlier, because the concern is you may get somebody who is fine, but you also may get somebody who decides to go off on a frolic of their own. And given how far-reaching the powers are for this particular post, I believe it's very important to have some form of, or some checks and balances. And the EOJ model, so you would have a board, the equivalent of a commission.
They were supposed to present something to us.
I mean, even in relation to INDECOM, that recommendation was made in the Joint Select Committee that reviewed the INDECOM legislation, that there ought to be a check and balance internally in the structure of INDECOM through a board that the executive director or the commissioner reports to. So, I mean, parliamentary oversight would be ideal, but we all know that it's not, given that we only have 63 members of parliament and 21 senators, the level of oversight that is required to be effective is not always possible. So I personally wouldn't be recommending to create another commission of parliament. We already have the Integrity Commission, which has been in effect for a year and a half, and we still haven't appointed the parliamentary committee that is supposed to be providing the oversight. So that mechanism really doesn't work very well. And I think it ought to have an internal board or something that this person is accountable to.
Right, we agreed absolutely that you shouldn't have the power resident in just one person, and that's why we are suggesting that we use the model of the EOJ. But that means it would need to be described in the
Correct, sir. So where you would see some of those changes in relation to the structure would have been in the schedule, essentially. So even though it was mentioned earlier, the changes would be reflected in the schedule, and the schedule, the first schedule on page 87 would be adjusted to reflect that particular recommendation. But Chair, I wanted to address the concern that would have been raised by Member Golding and also Member Robinson as well. And with respect to parliamentary oversight, we concur that a Commission of Parliament was not the recommendation that we had made for this particular entity. But that doesn't mean there isn't parliamentary oversight through the usual processes of laying of reports before Parliament and assessment of those reports as well. So Clause 58 of the legislation does require the Commissioner to lay annually before Parliament a report on his or her functions, as well as to lay ad hoc reports essentially before Parliament. And so that particular oversight is in fact provided in the legislation.
Yes, but Chair, in that regard, that entity will just be one of the plethora of public bodies that have that obligation. I don't think that's really the kind of oversight that Member Robinson and I were focusing on. Just one comment I wanted to make on the EOJ model or the ECJ model. That's a very particular model in the sense that it has nominated two categories of members. Some who are sort of independent, and then some who are appointed by political parties. I don't think we wouldn't have that. But the idea of a board, like the FSC, for example, like the Financial Services Commission has.
Just the idea of having
a board.
an oversight. Yeah. All right. we'll accept, well, on clause 15, we'll accept the changes to subsection 2 if there are no objections. So approved. All right, we'll move on to clause 16.
Chair members, clause 16 and clause 17, we could perhaps take those two clauses together because the concerns which were raised with respect to 16 and 17 are relatively similar. Clause 16 deals with the registration particulars that ought to be provided by the data controller. And then clause 17 speaks to the register which is to be maintained by the commissioner. The concerns that would have been raised in relation to these clauses related to whether or not there should be an inclusion of fit and proper criteria, and whether or not small businesses and clubs, for example, should be required to register, and if the fees that were to be determined in relation to registration, which are annual, are also will be determined based on consultation. And then there was a question as to whether or not the factor of registration could be inimical to investigative journalism. And that comment would have been raised by the Media Association of Jamaica. My apologies, Press Association of Jamaica. So in terms of responses, Chair and members, again, we were not of the view that there needed to be any requirement imposed under clause 6.1 for fit and proper criteria. Again, the information that is being required here is just to find out that if you are a data controller of any type, what exactly it is that you're processing, what is the data that you have, where are you located, what are the purposes for which you're processing this data, who do you intend to disclose this data to. That is discrete information that could be provided, that should be provided by any data controller. So there's no need to determine whether or not a person who processes data is actually a person who is fit and proper in the circumstances. And so it was not our view that any fit and proper criteria ought properly to be included in this section. The concern with respect to the registration is in fact annual, because when it is read, when the clause, that's clause 16, is read together with clause 17, it indicates that a data controller shall pay annual fees as may be prescribed for the maintenance of the required particulars of that data controller's data in the register, and no entry can be retained for longer than 12 months except on payment of that prescribed fee.
Madam Chair, on that point, you have to re-register every year, or you just have to pay a fee every year?
You have to pay a fee. You have to pay a fee. If it is that you have any changes, then under 17.2, you are supposed to notify the Information Commissioner as to any change of your information.
But you don't have to wait for a year to notify,
No.
right?
No, you do
at
not.
any point, you
At
can
any point
notify
in
of
time.
changes.
Well, when you say change of information, what do you mean? Like,
So for example, if you expand the scope for which you're going to be using the data, so you collected the data for purpose X, and you're going to be expanding the scope for which you're going to be using the data, you would have to notify that information to the Information Commissioner. If the categories of data subjects for whom you collect data expands or contracts, you should also notify the data controller in respect to that change as
if
well.
a company move from 10 customers to 20 and has data on the 20, they need to notify you. That would constitute information that would need to go to the Information Commissioner.
No, I wouldn't say that, because if the category is the category of persons still the same, if you just grow your customer base within the same type of customers, then you would only be doing the same thing, collecting data on persons or these categories of data subjects. It's only if that you're going, if you're
Different
collecting
scope.
additional data and additional information, then you would need to indicate that.
I mean, this is a new annual tax on businesses. You know, we just got rid of the minimum business tax, and we're going to be imposing a new one for those who have, you know, our data controllers. Do we have any idea what this fee is likely to be? And will Parliament have any say in how much it is?
Can't we say whether or not there is one?
These fees going to the consolidated fund? Is there a provision about how the office is funded? There's no provision about that?
You know, I don't know. Kadian, could you particularly look at clause 17, subsection 3, with regards to the annual fees, especially the part that says if you don't pay your fee, your entry will essentially be deleted from the register at the commissioner?
The concern being that once you register you and pay the fee, that it would be, well, there's a cost to the commissioner, of course, to maintain the register and to ensure that the information that is provided by the data controller, if it is updated, to update that information. And I believe that the policy, I shouldn't say believe, the policy here was to ensure that that the information commissioner was provided with resources to be able to keep that particular registry current.
Chair, is it?
Then if I were a business and I would just wanted, and I choose not to pay this annual fee and you deregister me, what are the implications of that?
Then you wouldn't be able to process any personal data, because in order for you to process personal data, you must be registered and your registration must be current. And again, that is to protect the rights of the data subject, because you are taking my information and you're processing my information essentially. And so you ought properly to be registered, and the data information commissioner ought properly to know what it is that you are doing with my data.
Through you, Chair, will there be any tiers as far as the different fees depending on the business, or is what is the fee? What does it look like? Have we, well, follow up, just looking at, let's not look at the European states, but what about the Caribbean islands who have a data protection? What is, and who charge a fee, what is their fee like? Do we know?
Well, the legislation wouldn't have defined the actual fee in those, but we're going to check to see if we can get some information, and we're going to get back to you on that.
Chair, could I just understand what type of entity this will be? Like, is it going to be like an executive agency where we have, I think, 3 different classes of executive agencies? Some are to be completely self-funding, some are to be partially self-funding, and some are to be supported by the budget. This is a kind of sui generis entity. It doesn't fit into, I don't know, but what is the financial concept behind this office? Is it going to be coming onto the budget as an additional public body that will have to be supported, but with some assistance from fees, or is it expected to be fully self-funding? You know, what kind of, has the ministry done any kind of projections as to what it will cost to operate this regime, the bureaucracy of it, I mean, and what the fees, how many data controllers are likely to register, and therefore what the likely fee, registration fee will be? Or are we just kind of creating law without that information being available?
Well, the expectation is that initially this particular regime would be a cost and a call on the consolidated fund and on the budget, essentially, and that this regime in its initial stages would not be considered to be one that would be self-funding at all. So even though there are fees which are prescribed in the legislation, it is not expected that this particular entity, and certainly not in its initial stages, would be able to run solely on the fees which are collected for either the services that it provides or essentially for what it undertakes. That's not the expectation. With respect to the assessment, the ministry has commenced the work of looking at what is the cost essentially to implement this particular regime. We started benchmarking or the Office of the Information Commissioner against other offices that would have been established. For example, the Office of the Information Commissioner in the UK, and we also looked at Malta. The cost structure, in terms of the cost, we can provide that information at the next sitting because we did do a financial analysis essentially of the cost, of the likely costs essentially to establish this particular office. And what I can say now is that the figure indicated was substantial. Based on what it is that we would have seen, because you would have needed essentially the Information Commissioner, you'd have needed investigators as well, and all of that.
If there is any other Caribbean country that has a registration regime, it'd be interesting to know what their fee structure was, or if not in the Caribbean, in any, similar country. And, just being mindful of the fact that the trend is away from expanding the number of public bodies and is in fact supposed to be contracting them, and the idea of expanding, so additional functionality or functions being imposed on an existing body that, so it becomes a hybrid as a way of achieving or not departing from the goal of reducing the cost of the public sector overall as a percentage of the economy, is something which I think we should be mindful of. We just passed fishing legislation, I think, which created 3 additional bodies. Whereas, for example, when we were looking at establishing a human rights institution, which I think the Minister of Justice is still looking at, the approach that was being taken was to expand the role of the public defender to include that function. Similarly, when we wanted to establish a special rapporteur on human trafficking, we expanded the role of the children's advocate to do that. And these are ways of trying to avoid creating whole new bodies of person and all the costs around that. So I don't know if any thought has been given to this. But, I think it's we need to start to condition ourselves to thinking in that way when we're dealing with setting up new systems, legislative systems.
Thank you very much, Chair. Actually, we will recall that this particular legislation actually suggests that the Information Commissioner and will also take on responsibilities under the access to information legislation. So as a matter of principle, there'll almost be like an ill effect once the required amendments are in fact made to the ATI legislation as well. So that was the contemplation. So the single office of the Information Commissioner would be responsible for data protection along with access to information. And that was a policy consideration.
Currently, that access to information, the bureaucracy around running that legislation is housed within a ministry. Yeah, so it's not really like a separate public body in its own right, whereas this is going to be one. Anyway, in the next sitting we'll see what their analysis is of the likely cost of it. But,
Sorry, just to respond, you had asked for earlier, Member Golding, about whether it was going to be an EA, but Section 4.1 establishes it at a body corporate, to which Section 28 of the Interpretation Act applies. And then if you go to the first schedule, page 90, right at the end of the first schedule, you'll see how it is funded. Which consists of fees and other sums received by the Commissioner, which would also include funds from Parliament.
I think we can go ahead and put to the members clause 16 and 17. We recognize that the ministry needs to come back next time with some information with regards to the budget, projections, any benchmarking that was done in order for members to understand the likely cost of this entity.
And if they have any idea of how many data controllers they think there are out there, what is the likely size of the register in terms of persons on it? If there's any, any work has been done on that.
All right. So we will take those two clauses, 16 and 17, and if there are no objections, we'll move forward. No objections. We'll move forward to clause 18, which is a clause that we'll be looking at the offenses.
Chair and members, with respect to clause 18, it creates the offense essentially of processing without registration, which answers the question that would have been raised earlier about what if it is that one part of the question, what it is if you actually are processing and you haven't registered. It creates a criminal offense. Some of the concerns that were raised by the stakeholders was one that the fines essentially, as well as the term of imprisonment, was actually considered to be onerous, and that we ought to look back at the particular fines. The other concern was that the clause 18.2, which actually requires that the person charged with an offense can put forward a defense to show that he or she exercised all due diligence. The requirement of all due diligence, it was felt that that was considered to be too absolute, and that what should be there should be all reasonable due diligence. When we looked at various pieces of legislation, for example, we looked at the Barbados privacy legislation as well as St. Lucia, we found that the monetary penalties that were recommended in the bill would have been consistent with what we were seeing. So we saw from a low of just about 500,000 Jamaican dollars to a high of 15 million Jamaican dollars essentially as the fines which would have been imposed. We think therefore that our fine structure, which is here, is adequate to reflect the severity of the offense of processing information if it is that you have not registered. However, we are recommending to the committee that if it desires, it could consider reducing the term of imprisonment. So we currently have, where it is that there's summary conviction in a parish court, a term of 2 years, and a circuit court, 5 years. However, we are aware that in legislation there is usually a correlation essentially between the fine which is recommended and the term of imprisonment, and that correlation would have been what was reflected in this particular provision.
Chair, if I may just ask, this offense of processing without registration doesn't involve any implication of a breach of standards or any misuse of the data in any way. So it's really a failure to comply with an administrative requirement. I don't see in that instance why there should be prosecution in the circuit court, for example, for this offense. I don't understand that. That seems to me overkill, because I would imagine that if some abuse of personal data has taken place, that's a different matter and would be charged under a different section of the Act that is dealing with misuse of data or breaching the standards. But just purely failure to comply with the administrative requirement of registration, to my mind, 2 years imprisonment seems excessive, and I don't see why this matter would have to go into the circuit court at all.
Chair, it would be a matter for the committee. We certainly at the ministry wouldn't have a challenge with the recommendation if it is that it were to be removed.
Members?
You can imagine, let us say a church, a small church in Augustown that has or in Trenchtown, that has a computer on which it has a database of its members and information about them. And, it hasn't applied for an exemption. It may not even be aware that there is any facility for an exemption. And it's, run by persons who run churches, and its membership are the kind of people who are members of churches. And they may not be au fait with all these requirements and so on. Next thing you know, some officious constable who has some other reason to be annoyed with somebody senior in the church decides to charge them under Section 18 of this act and says, you can go prison for 2 years. It just seems really
Member Golding.
Chairman and colleagues, the fees that are in the bill were considered in such a way to ensure that we have a certain level of compliance and afford a certain level of protection to the citizens who will be affected by the privacy. And as such, if it is that the fees may be outside the fines may be outside that of the court to which the bill speak, then we have to ensure that it falls within that regime that is afforded at that level, at that court. So the fines, I beg members to not look at it from just a mere cost or to the data controller, but more to look at to ensure that they adhere to the regulations, they adhere to what the act stipulates. Oftentimes we create laws, and within 3 to 5 years, the fees or the penalties appears to be nothing more than just a token, and persons will just gladly break the law because the fees or the fines are not substantial to act as a deterrent. So we want to, I'm sure Member Robbins will recall the early days when we were putting together this, we started discussion on this matter, and the matter of fees came up. And I think in fact the $2 million that is there, we had considered it during the early stages. And OP, we are not contemplating now to reverse that decision because of some other reason.
Member Golden, and you can correct me, you're just speaking to
the imprisonment.
The imprisonment,
yeah.
right?
And
conviction on indictment.
Two things here. The fact that I don't think this should be an offense triable in the circuit court. I think that's completely, to my mind, unnecessary and inappropriate. And I think that the term of imprisonment for non-registration is excessive. That's my own view. I wasn't really focusing on the fine. But on the issue of fines becoming out of date, as the value of money changes over time, we have been, in recent times, including provisions which allow the minister by order subject to affirmative resolution to adjust monetary penalties in legislation because of that very reason. I don't know if that provision is in this bill, but perhaps it should be.
Gideon?
Chair, just checking to see if this clause would fall under that. No, this one would not be one that would be adjusted in the manner that would have been described by Member Golding.
So how would this be adjusted?
You would have to actually.
You'd have to
come back and amend the legislation. Correct.
Yeah, I think we should have an easier mechanism for updating the fines. Yeah, that one that requires Parliament to bless it, yes, but doesn't require you to go through the whole legislative process of new legislation. And it's very normal. Most, certainly many, if not most, I would think most pieces of legislation that provide for fines in recent times have that provision in it.
All right, members, I'm going to put to you clause 18, subsection 3B, as to whether or not we make changes to the fact that you could be convicted, that you could bear imprisonment for a term not exceeding 5 years if you are convicted on indictment in a circuit court because you failed to register.
Chair, just a administrative thing. How long you plan to go today?
My plan was until 3 o'clock. All right. How should I interpret the silence with regards to clause 18, subsection 3B? Let me put it then that we would agree to omit from clause 18, subsection 3, part B.
Yeah, I would be in favor of that. I think, having this an offense tried in the parish court is a sufficient deterrent for the type of offense we're talking about.
Is it that if I am charged with this crime and I do not pay the fine that I can go to jail, or is it that the judge has the discretion to choose whether fine or prison based on whatever determination? As worded,
you could be fined, or you could be given a term of imprisonment. And if you're fined and you don't pay the fine, there's other legislation that sets out the consequences of not paying fines, and that would typically be you'd be incarcerated until you pay it. Mm-hmm.
The deletion is so moved. Okay. So we'll move on to clause.
Chair, if I may, just to clarify, the committee was considering or deliberating on whether or not they should be subject to imprisonment, and we're agreeing that we're leaving the imprisonment provision in relation to the parish court.
Yeah, yes. I mean, I think 2 years is a bit long personally, but for this type of offense, but it says up to, not exceeding, it says. I don't think any magistrate's going to send it, any parish judge is likely to send anybody to 2 years for non-registration, but you never know.
All right, we'll move on to clause 19.
Excuse me, Chair, just excuse me. The Criminal Justice Reform Act, though, would apply, and it says that if you're liable to be sentenced or to serve a custodial sentence, the judge has the power to impose something else, which could include, for instance, electronic monitoring.
I think we need to ensure that there's no ambiguity and as relates to the interpretation of the law. And just in a side discussion with Member Golden, maybe we need to stipulate clearly that not $2 million or to imprisonment for a term not exceeding 6 months. I think that, at least in the first instance, let us look at it first 6 months, and then thereafter, if we find that person's think 6 months, a 6 month stretch is a holiday, then we then revisit
and
it.
The only reason why I think imprisonment is probably necessary at all is because for a very large corporation, a $2 million fine is not necessarily adequate punishment. But, doing any jail time in Jamaica is a real punishment.
Hold on, if we go to 6 months, though, if it is determined that it should be longer, then we have to come back and amend this act, right?
However, Chair, I do recall that there was a recommendation on the table to make this provision and allow it to be changed by affirmative resolution. The monetary penalty. Right.
Yes. All monetary penalties in the Act, I think, should be subject to that. There should be a provision added to do that.
There is another option. You could have for a first offense the 6 months. You could have for a second or subsequent offense the same kind of fine and a higher custodial penalty.
Yeah, if we want to make it more complicated, we could do that. It's true. It's true. You know, if you have recalcitrant persons who don't.
So, Chair, we leave the clause as is? Their suggestion? Was that tiered
Endorse
structure?
the proposal by Member Wheatley that it be 2 million, a fine of 2 million or 6 months. Yeah, and you know, if you serve your 6 months and you still don't register, you do another 6 months, and so on.
Okay. So I put the amendment to clause 18, subsection 3A, to change the imprisonment for a term not exceeding 6 months, and we add another 6 months. No, okay. So we change that to imprisonment for a term not exceeding 6 months, and we delete clause 3B. 3B. Well, subsection 3B from clause 18. Yeah. All right. So we move on to clause 19.
Clause 19, Chair and members, deals with the requirement for an assessment by the Commissioner to determine whether or not what the data controller is doing is considered to be specified processing. And the specified processing here is processing which is likely to cause substantial damage or distress, or otherwise significantly prejudice the rights and freedoms of data subjects. The concerns which were raised with respect to this particular provision were raised as follows. One concern was whether or not there would be any criteria for the minister to determine what is considered to specified processing. Again, we had a concern raised as to whether or not the terminology of substantial damage or distress was too subjective. We had discussed that on the last occasion, and whether or not there ought not to be a greater definition essentially for the terminology about substantial damage or distress. There was also a concern that would have been raised in relation to the subjectivity that is given to the minister to determine whether or not something is considered to be specified processing, since the order is one that is made by the minister, and whether or not there would be any sort of harm to investigative journalism because of that subjectivity. In relation to the concern that was raised, members and chair, in relation to whether or not this particular provision could affect investigative journalism, the ministry would have sought the advice of the Attorney General's chambers. The advice of the chambers is listed in our analysis and recommendation, and I would ask the chambers to outline for the benefit of the committee what was its finding in relation to the assessment on clause 19. We're on page 67 to 68 of the bound copy of the document.
So, when we were asked to advise in relation to this particular aspect of the balancing of the right, that's freedom of expression versus the right to privacy, it was not only within the context of clause 19, but with other clauses such as clause 10 and certain exceptions, for example, for journalistic purposes. So I'll say broadly, what our research has revealed is that these two rights, that's the right to freedom of expression and privacy, has often caused problems from a case law perspective. And so the courts have been at pains to say that there has to be some amount of balancing exercise, because you recognize that the type of information that these types of legislation covers relate to your personal data versus the right to freedom of expression, which both rights of which we have in our Constitution. So when we look at the wording of Clause 19, it seems to be consistent with the standard that one really has to meet if one is going to say that the right to freedom of expression should not trump one's right to privacy under the Constitution. So from the perspective of the wording that is used in Clause 19, the substantial damage or substantial distress, it's a higher level that is required to be met before it can be said that the right to freedom of expression, there is no reason to derogate from the right to freedom of expression. So from that standpoint, what we're saying is we have not found, in light of the authorities, that there is anything inconsistent with raising the standard so high. In relation to the minister's power, while we recognize that the minister is being given a discretion in relation to making an order relating to specified processing, it's our view that general principles of administrative law, which govern how a member of the executive utilizes his powers, would be applicable here. And in so doing, there is still a higher standard that's required, because again, the minister is making an order in respect of something that could either impact on either a person's right to privacy or the freedom of expression. So certainly we believe that the provision as drafted poses no problem in terms of the arguments that the media associations would have been making.
Thank you very much, Chair. And it was on the strength of that advice from the chambers that we recommended that there be no change to this particular clause, save and except that there was a recommendation for an insertion to be made at Clause 19(1)(a). So at Clause 19(1)(b), it indicates that, and I'm to read the section, an order made by the ministers in accordance with Section 76 as appearing to the minister to be likely to, and I'm reading B, to otherwise significantly prejudice the rights and freedoms of data subjects. It was felt that in Clause 19(1)(b), since there was a reference to data subjects, there ought properly to be a similar reference to data subjects in Clause 19(1)(a), so that it would read, is particularly likely to cause substantial damage or distress to data subjects. That would have been the only recommended insertion.
Chair? Just one, reading this section, this clause, quickly, I'm not really clear on what it's designed to achieve. So the minister makes an order, again, saying that processing of a description, this processing of a description specified in the order is likely to cause data subjects damage, distress, or prejudice their rights and freedoms. So there will be some order which sets out processing of a certain description that meets that test. And then 2 says that the commissioner now, on receiving information from a data controller, has to consider whether or not there's likely to be compliance with this act, and then give a notice to the data controller stating the extent to which the processing is likely or unlikely to comply with the act. What does that achieve, and where does that take us in terms of protecting anyone? I just found 19 to be a lot of words, but it wasn't really clear to me what it actually does and what it's hoping to achieve. It's a lot of words, and there's a criminal offense attached to it and all of this, but in terms of its likely efficacy at giving protection, it didn't jump out at me as really being likely to do that. And I was hoping maybe the ministry could explain what they think it does.
So, Chair, this particular clause, and we have to put it in context, we will acknowledge that this particular clause really is a clause that replicates a clause that was deleted from the UK data protection legislation. It was found in the 1998 legislation. It's not a clause which is repeated in the current legislation. And the intent, and also to share as well, it was also found as well in, I believe it was a Maltese legislation as well when we had done our research, another legislation that would have been repealed. At a particular point in time when it is that the legislation, the bill would have been drafted, the understanding, or certainly the policy, was that we wanted, because of the nature of the type of processing essentially that was being considered, we wanted to give the Information Commissioner an opportunity to be able to assess whether or not this particular type of processing was one that required a higher threshold from the data controller. And so in the circumstances, once there's an assessment that is undertaken by the Information Commissioner, it is expected that the Information Commission, the data controller, would comply with whatever requirements that the Information Commissioner would impose if it is that this type of data, that is data which is likely to prejudice rights and freedoms, but there was still an overarching reason for you to process that data in terms of how you would do so.
Not seeing anything in here that, provides for the issuing of directions or directives as to how we are to do this processing, which is so sensitive, or it's not like a regulatory provision that allows the regulator to tell the regulated entity how to behave or how to conduct itself in this regard. It doesn't seem to have that in it. I'm not surprised the UK legislation abandoned it.
There is an assessment at 19.2b2 that the assessment is basically whether or not the processing of the nature which is to be undertaken is one that actually balances the rights and freedoms, because it speaks here whether it's likely to comply with the provisions of the legislation as well.
You give a notice saying it's likely to comply, or you give a notice saying it's not likely to comply. Where does that take you? I mean, what you'd have thought it would be more prescriptive or enable the commissioner to give directions as to what should be done in order to ensure compliance or to minimize any risk of non-compliance. It just doesn't, that piece all seems to be missing. It's just a notice saying whether you're likely to comply or not. And then you have this whole big regime about extensions of time and a criminal offense attached to it. And it just seems to me like much ado about nothing.
So, if I might clarify, 2B allows the commissioner to give an assessment as to the extent to which the processing is likely or unlikely to comply. So, if the commissioner indicates to the data controller that if you process it, the data in this particular way, as you indicated that you intended to do, it's not likely to comply with the provisions of this act, and then the data controller goes ahead and still does the processing despite having received that assessment, then that is where the offense provision under the section would then apply.
Okay, Dan, can I give an example?
Dealing with future conduct, or this is dealing with how you are now processing data as a data controller?
Likely to. So it'll be during future conduct. Yeah. Because and in terms of the structure, and I'll say that because look at this, just look at the structure of the particular provision. So registration would have taken place in clause 16, where you would have indicated essentially to the Information Commissioner what type of data you'd be collecting and how you intend to process that particular data. It was based on that registration essentially that the data that the Information Commissioner would undertake his or her assessment as to whether or not how it is that you intend to process this particular data, whether it is likely to cause the sort of prejudice that is referenced here, or to cause damage or distress in the circumstances. Hence, it is preemptive.
We're introducing this legislation not in a society that's about to start operations. we're introducing into a society that's conducting this stuff already, and so when these people who are being applying to register for the most part will be existing data controllers. There may be some who are going to getting into it, but the minority, most will be existing. So they will provide information when they register. Some analysis will be done as to whether or not it has this potential to be damaging or not. But it just seems to me that in 2B2, just saying to the extent to which it is assessed as likely or unlikely to comply with the Act, just doesn't go far enough to be of much use. I would have thought that if it's assessed as being likely not to comply with the Act, then there must be some ability to give directions or prevent them from processing it, to a cease and desist or conditional cease and desist. If you don't make these adjustments or put this in place, then you can't process it. But there's nothing in here that allows that. And I'm not sure why we're keeping a provision based on a UK Act which has been repealed. If the provision has been repealed in the UK, there would have been a reason why they repealed it. Why are we keeping it? Especially when it seems to have this defect.
Okay, Diane, any additional comments?
Well, Chair, our view is that this particular provision allows the Information Commissioner to provide guidance to new and existing data controllers who would be operating under this regime as to how to deal with information that they're currently processing and information which is likely to do the two things which are referenced here. Again, while we recognize that this provision would have been deleted, we are starting a regime essentially where we are providing guidance to data controllers as to how they ought to operate, and as to the likely effect of their processing is something that we believe is critical and important in order for this regime to move forward. And for this reason, we would suggest that this particular provision or this particular clause remains in the legislation to allow the Information Commission opportunity to provide guidance to data controllers in relation to these types of, in relation to information or to data which is likely to do what is stipulated here.
Members, put in clause 19 and the recommendation that this be kept in. Somebody
Chair.
else?
I'd just like to speak to the recommended amendment, proposed amendment that was made by Mrs. Smith about inserting the words "to data subjects" in 1A. I think that would require consideration as to whether the persons who it's desirable to protect against substantial damage or substantial distress are really only data subjects alone, or do we want to protect other persons who might not necessarily be subjects of the data that is in the specified processing? I think those words, the words "to data subjects" were not included because it perhaps might be a case where the specified processing might actually affect people who were not actually the subjects of the data, but for some reason it might still cause them substantial damage or substantial distress.
But I thought data subject meant anyone. Any Jamaican citizen is a data subject once this regime comes into place.
Yes, but with respect to the definition, any citizen is potentially a data subject, but in this context, it would have to be the person who is actually included in the data, is mentioned in the data concerned.
So what do you suggest? What term would you suggest we use to capture any potential interested party, whether they are a data subject or otherwise? What term would you suggest for us to use at that point?
Through you, Chair, I think the recommendation that's been made by the CPC is that the amendment that is suggested, that it not be taken, that the legislation remain as is. So there's no insertion of the term to data subjects. So it would remain.
So you're saying if you insert to data subject, it would restrict it? It would restrict this clause, or the opposite?
There's a potential restriction because of the nature of how data subjects are defined, or how it is defined in the legislation. That's the recommendation that's been made. Should not include 19(1)A.
All right, members, I submit clause 19.
Yeah, I mean, in my view, I think we should consider removing clause 19 or amending it. Not so much in relation to the addition of the words to data subjects, because they're already covered if the words are not included, and putting those words in apparently could be considered narrowing the provision, but more on the efficacy of the clause as a whole, and the fact that it doesn't really give any clear, it doesn't create any clear mechanism for dealing with the situation that it's grappling with in that 19(2)(b)(2) provision, and the fact that it has been repealed in from the very act where it had its genesis. There must be a reason why that was done, and I think we ought to know why it was done. But I would be reluctant to include a repealed provision where the provision comes from a piece of legislation in '98. That Parliament has repealed that provision subsequently, and we are keeping it. We need to know why they repealed it.
Chair, we'll undertake to provide the committee with the rationale. However, when we're looking at this particular provision, even in our own review, we were not violently opposed to whether or not the provision would remain or not. We contemplated that the committee might have a challenge essentially with this provision, and so the ministry does not have a challenge with having this provision deleted, but we could defer that until we're provided with the rationale, so that at least when the committee is making that decision, the committee will make that decision understanding what the rationale would have been.
That sounds sensible to me, Chair.
All right, so we will defer voting on clause 19 until the next meeting when MSED comes back with the rationale for using a repealed clause that's not in the current UK legislation.
Chair, just to say, though, at the time when the bill was drafted, it wouldn't have been repealed. It would have been in the legislation that was current at the time.
But now we know that it was repealed.
So this is a recent, what the term for repeal? Repellent? And a repellent? When was this done in the UK?
2018, May last year.
Okay.
Okay, we'll move on to clause 20, appointment of data protection officers.
Chair and members, we're at the end of part 3. Part 3, which speaks to the requirements for data controllers, and the last requirement that a data controller has to meet in relation to its operation under the data protection legislation is the appointment of a data protection officer, and that particular individual is responsible for monitoring in an independent manner whether or not a data controller complies with the provisions of this particular bill. The comments, Chair and members, would have been varied again. One comment was that all entities should not be required to have a data protection officer, as it was considered that this could be onerous on small businesses and again could amount to overregulation. The other concern that was raised was that the law should provide some kind of qualifications or a listing of expertise that would have been required for data protection officers, and that even the concept of requiring a data protection officer within an organization was equivalent to self-incrimination, and that there was perhaps an inherent conflict between an employee being an individual who is the data protection officer if that employee is still receiving a salary from the data controller. Again, there was a concern raised as to whether or not guidance would be provided to determine in a specific clause the meaning of independent manner, and that was with respect to clause 20 subsection 4. In reviewing this particular section, again, Chair and Ministers, the Ministry's position would have been that because of the nature of the regime that we are starting, it being a new regime, we were of the view that the requirement for a data protection officer was one that should be imposed on all data controllers. And so that was the context within which our recommendation would have been made. We'll start off by looking at the request with respect to qualifications. It was not, or we certainly didn't find within our research that any legislation would have listed any qualifications or expertise that would be required for data protection officers. Rather, it would have stipulated that the individual ought properly to be someone who had expertise, I shouldn't say expertise, somebody who was knowledgeable essentially with respect to data protection. It didn't state whether or not you needed to have a degree or whether you need to have a particular level of experience in terms of 20 years of experience or anything like that. And we didn't think that we should provide that kind of prescription in the legislation. Even the GDPR from our own research indicates that the person should have expert knowledge of data protection law and practices. That expertise could have been acquired based on academia and study, could have been acquired based on experience over time, and so we felt that leaving it as it is right now and for data controllers to determine the person that best reflects the type of expertise that is required was something that we should do.
On that point, I don't think, given where we are, we could be imposing any kind of threshold qualifications on persons to be appointed a protection officer, because where would we find those people? We're starting from scratch. So I think I think the bigger point for me is whether all data controllers should be obliged to do this. I mean, we have precedent in Jamaica for less onerous requirements for smaller businesses. Under the Companies Act, for example, businesses that are below a certain size, whether in terms of a number of employees or turnover or assets, do not have to comply with IFRS in their audited accounts. They can produce accounts that, as long as they are satisfied that they give a fair, true and fair view, but they don't have to get into all the complexities of IFRS in their accounts. You know, we recently increase the threshold for GCT registration to take some of the administrative burden off of small firms of having to file GCT returns, you know. So there's that kind of outlook as to how we manage smaller companies, smaller businesses is something which is precedented here. We have that. You know, I just think to require a small firm to have this protection officer. I mean, it's in a small business, people are usually maxed out already, and they do, they're multitasking and what have you. How realistic is it really to expect somebody to take on this statutory role on top in a small business?
Member Golding, I remember during the discussion we had at the ministry, it was thought that small firms, SMEs, could hire this service in much the same way that they hire auditor services. Outsource it. It doesn't have to be somebody within the company.
Is there any model where there is a threshold below which this isn't required of them? Because if they have to outsource it, they're going to be paying a hefty fee for it. You know, in fact, small companies, as long as all the shareholders agree, don't even have to have audited accounts. That's how far we went in Jamaica. If all shareholders agree that they don't need to have their accounts audited, there's no need to have an audit done, because auditing accounts is expensive, and not all companies can really afford it if it's a small business. So, you know, I would have thought if there is a model elsewhere which allows smaller firms to avoid having to take this on, we ought to. Given our promotion of MSMEs, and we're trying to grow the economy and grow employment, and we know that MSMEs are key to that, we shouldn't try and burden them with additional requirements like this, if there are models which are working elsewhere which haven't done that.
Kaden, before you answer that question, just enlighten us. Is it possible to, seeing that there's a concern as relates to small entities, that we look at the the number of subjects that they're dealing with. And based on that, we put in place a tier system, and that will, of course, determine the level of qualification that is needed. Because, of course, you would want an entity such as a bank that is dealing with quite a large number of data subjects, that they put in place a more, a system of persons qualified to deal with such large numbers and have a certain level of understanding of dealing with that large data group relative to a small entity that deals with around 10 persons. You know, so I think we can examine that to see if it is possible for us to implement that, just as with the GCT, where entities doing business under $10 million that they are exempted or so forth. But you would want to ensure that each entity that is collecting data, whether you're small, whether you're large, that you take into consideration the rights of the subjects that you're dealing with as relates to data protection. So there cannot be any exemption once you are treated with data, personal data. Otherwise, it would defeat the purpose of this piece of legislation.
So in response, Chair, the Ministry did consider the very concerns which have been raised by members. And in fact, in other jurisdictions, they have different systems that you could use. So for example, some jurisdictions indicate that you would appoint a data protection officer based on the number of data subjects that you have. So if you only manage a very small number of data subjects, for example, versus a large conglomerate or large number of data subjects, then if you are an entity with a small or large, but your number of data subjects was large, then you would need a data protection officer, versus if you're a large entity with a small pool of data subjects, you wouldn't need one. Some countries also limited it by virtue of the type of data that you are processing. So if the nature of the data that you're processing is such that it contains more sensitive information versus less sensitive data, for example, then the more sensitive would require a data protection officer in those circumstances. Additionally, when we were doing our internal research, we considered that the committee could look at restricting the appointment of a data protection officer based on categories of persons. So if we look at, for instance, the current MSME policy that determines what is a small, medium-sized enterprise, then you could, for instance, determine the need for a data protection officer based on those. So for instance, if the size of the business has a particular annual turnover, then if you fall below that threshold, you would not require a data protection officer. If you have a higher threshold, then you would require a data protection officer. Or if the number of data subjects, for example, that you're processing is known, then we do it based on the number of data subjects that you're processing. And again, we also suggest the type of business. So it's possible for the committee, in looking at this particular provision, to determine that it would not require all the data controllers to be registered, but would limit essentially the requirement for a data protection officer to those data controllers essentially that were either processing particular types of data, have a particular number of data subjects, or would have some other type of criteria that would determine essentially the business that was being operated, whether your annual turnover, yes or no, or some other criteria.
Did you do any research to look at how it treated NGOs, club societies, political parties, those churches, entities that are not in the business of making money, non-profits, and there are a whole set that would fall under, the Data Protection Act?
No, we didn't actually, in looking at it, limit it to assessing whether or not for example, clubs and societies would have been required to have a DPO. We didn't find, I should say, in the research that countries limited it to that. So you're a club or a society, but rather just a category essentially. But we can come back and look. We can come back to the committee to see if there are any. But our research did not indicate that when we were going through the countries at all. We didn't find that.
Chair, a regime that said if you fall within an MSME category as defined, you're not required to have this officer unless your business involves an intensive number of data subjects data. In other words, you're very intensely in that area, or the nature of the information that you have is particularly sensitive. If either of those two criteria apply to you, you would, regardless of being an MSME, you would have to have this officer. But for the vast majority of MSMEs that wouldn't either be processing particularly sensitive data or wouldn't have information about a large number of data subjects, they wouldn't have to comply with this. I think we should consider something.
But even if they don't have a large number of data subjects, what if the data is sensitive?
Yes, I'm saying either of those, if they're handling sensitive data or if they're handling data for a large number of subjects, then they wouldn't be qualified for the exemption. But if neither of those apply to them and they're an MSME, then they should be exempted.
Katie, and we'd have to go back and do the research on this part. You know, I would lean more towards looking at the sensitivity of the data rather than thinking about the size of the MSME in terms of revenues or any of those criteria, because what we're talking about here is sensitive personal data.
So, Chair, I understand to be saying that you would want the appointment of a data protection officer to be based on the type of data that is being processed. So it's a type. So it's a.
I think we were talking about if there were changes, what would be the likely criteria that we would use for exemption? And I'm just saying that a criteria that looks at the financial size of the company would not be an appropriate criteria for this.
Okay. So we can come back with some language. We had some language with respect to this. We actually had a recommendation in relation to what it could look like, and it would also look at the type of data that would have been processed. So we can come back with some language, Chair.
All right, so we're deferring clause 20 until the next meeting. All right, we'll move on to part 4, standards for processing personal data. There are 8 standards, beginning with clause 21, duty of data controller to comply with standards.
Thank you, Chair. Clause 21 outlines, first of all, the first standard, the first requirement essentially with respect to standards for processing, and it provides that if a data controller, and this answers the question that would have been raised earlier as to what happens where a data controller processes in contravention of the standards, and it stipulates that a data controller is required to comply with the data protection standards, the 8 standards which we'll discuss shortly, and if the data controller processes in contravention of these standards, then the data controller commits an offense. It also provides that in respect of the requirements of the data controller, that the requirement isn't only to operate with respect to the data protection standards, but also to notify both the commissioner as well as the data subject in specific circumstances whether or not there has been any kind of data breach as well. And then outlines how the commissioner ought properly to respond or operate if he receives a report, essentially that there has been some sort of security breach. The comments on this section that we would have received, that would have been raised by stakeholders, was that the requirement to report again placed an undue burden on the data controller, in particular where the data controller was a credit bureau that was already required to report security breach under another legislation, in this case a credit reporting legislation. There was also a concern that the terminology of undue delay was vague, and that rather than undue delay, there needed to be greater prescription in relation to the time period by which a data controller was required to report a breach. And then similarly, there was a concern that was raised as to whether or not the information that would have been shared with the information commissioner would have been information that would have been treated in a confidential manner, given that we're talking about breaches of security within organizations. And then the issue of the fines was raised again as to whether or not the fines would be onerous, and whether or not there were any safeguards that would be in place to protect data before a breach would occur. The threshold was also raised as a concern as well, and it is in clause 21.5 that the word likely as a threshold was really a low threshold to impose on the data controller, and that a higher threshold should have been stipulated. So, Chair, with respect to the Ministry's review of this particular clause, I'll start off by sharing that the Legal Reform Department would have done an assessment of this clause as well, and would have shared with the Ministry its concerns in relation to the use of the terminology undue delay. It was a recommendation from that office that we adopt similar language that would have been found in other legislation. And again, the GDPR was one recommendation which stipulated that while you should report without undue delay, it gave a time period by which you were supposed to report notwithstanding. And so if I would allow the LRD to share its concerns before I go to the others that the Ministry would have.
Thank you, Chair. Good afternoon. Okay, the Legal Reform Department was concerned that the term undue delay, that term needed to be need to have a more precise meaning, explanation, or that a more precise arrangement be put in place that would address any perceived vagueness or subjectivity to the term. We looked at Article 33(1) of the GDPR, and we looked at the UK Data Protection Act 2018, where in the UK, what they did, which was similar to what occurred in the GDPR, they kept the undue delay, but they also indicated that where feasible, not later than 72 hours, that a report was to be made to the Information Commissioner, and where the notification to the Commissioner is not made within 72 hours, then reasons for the delay must accompany the notification. So we're just saying so that the term undue delay is not, ongoing on and on and on, just to put a little more preciseness to the term in the bill.
Chair, with respect to the concern, members would have seen the comments of the Ministry at page 73. Page 73 of the bound copy, and our comments, I don't believe, run contrary to the recommendations of the LRD. We were suggesting at the time that the term undue delay not be replaced with any specific timeline, and what the LRD is suggesting is that you are given an option, that you must do so without undue delay and certainly no later than 72 hours. So if the committee is minded to accept that particular recommendation, the Ministry wouldn't have a challenge with it.
I mean, it's hard to. We'd normally have a criminal offense with such a imprecise yardstick of conduct, as to when you are or not in breach of it. So I think that to say without undue delay and in any event within 72 hours, unless it is impractical to do so, something along those lines is appropriate, so that if they don't comply with the actual specific time frame, then the onus would really be on them to show that they couldn't reasonably have been expected to do so because of whatever circumstances they were in.
All right, we'll...
Amendment accepted?
Pardon me?
The amendment is...
Right. Members, we accept the amendment. Could you read it for us to make sure we understand?
So the amendment that is being recommended is to clause 21(3), where a data controller would be required to report to the Commissioner without undue delay or not later than 72 hours, and it would continue any contravention of the data protection standards and any security breach. That's not the technical drafting language, but that's how it would look.
Or not later than 72 hours, yeah. I'm sure very often we hear in the news in the US companies that have reported data breaches. That's what we're saying, right, Kadian? If there's a breach of data, that it be reported immediately.
Immediately,
yeah.
That's correct, yeah. And then adding some time period as to what immediacy would look like, yeah.
All right. All right, I put to the members clause 21 with the amendment.
Rather than use undue delay in 3, and it's again in 5, maybe 3 should have the words, a more positive formulation like forthwith or immediately, and in any event within X hours, some specific, because when you're talking about in 5 now, notifying data subjects of the breach, that's, the practical implications of doing that and how you do it are a little different, I would imagine, to how you inform the commissioner. So to use one, I think the obligation to inform the commissioner should be an immediate obligation. The obligation to inform data subjects should be without undue delay, which would take into account, I think, the circumstances, how many people there are, how do you reach them?
But wouldn't you say, let's say one of the large banks found out that there is some breach, and they informed the data controller immediately, putting out a notice on radio or something to say, our data has been compromised, as I hear, in terms of U.S. companies, wouldn't that be like an immediate way to reach people? And you would know, I would know I'm a client of the particular bank or the particular institution.
Yeah, I would think for a large institution like a bank, it would be easier for them to do something with alacrity, maybe than a more modest organization may have a disparate number of data subjects, and to go and inform them. Is there anything about how this how they are to be notified? Does it specify how the notice is to be given? I don't see anything in here as to how it's to be done. I mean, can it be done by a radio ad, or do you actually have to get notice to them of it to make sure they've heard it? Because not everybody listens to radio all day. And we're talking about a criminal offense here, so it's quite important that it be very clear as to what conduct breaches the provision and what conduct doesn't. But my only point was in relation to 3, which is the one we were just looking at. Rather than say without undue delay, we use words like forthwith and then put up and clarify what that means by saying in an event within 72 hours or whatever it was we were discussing.
Ministry?
Chair, just a clarification. We were looking back at the recommendation in relation to undue delay. Recommendation that was made, and I believe the AGC had some concerns about the...
It's not really a concern. I'm just saying we don't usually put terms like undue delay forthwith and then we're going to put the timeline. If you want to put a timeline, just put the timeline, because at the end of the day, the timeline is going to be what governs whatever is before it. So when we put a timeline with undue delay is then going to have to be interpreted with respect to that timeline. So if you want 3 days, then just say up to 3 days. Undue delay, forthwith, all of these terms are understood in law. They have meaning. There are cases where you bring them when the court considers them. There is usually some learning about what they mean. If you think it's too imprecise and you want to put your 72 hours, then put 72 hours. But I don't think it makes sense to mix the term undue delay with the timeline. I think you pick one. A suggestion.
I think if it's a criminal offense, which it is, then the specific timeline is better than undue delay, which is very context driven. You know, what is undue delay depends on the context in which this thing has arisen.
But that's exactly, if I may, that would have provided grounds for the person then to be able to give a defense as to why there was a delay. But if you put the 72 hours, then it's strict. You would have to meet that obligation.
But at least the court, if you're talking about criminal conduct, you know whether or not that person has fallen on the wrong side of a line. You know, to assess criminal conduct by reference to vague phrases like undue delay, to my mind, doesn't lend itself to that kind of adjudication.
Chair, I want to go back to a point raised by my colleague, Member Golan, in 5. And he asks about how would a subject be notified. And I want to go a little bit into it. So let's say it's one subject. Is the entity allowed to send them a mail, which might take 2 weeks, to the subject? Are they required to do a press release? You know, you can defeat the objective of the clause if you're not specific about how the notification should be done. Now, I was just thinking aloud, should the notification be to the subject, or should the onus be to the commissioner, who then determines the appropriate way to inform the subject? Because you know, no entity willingly likes to acknowledge that there's a breach, because it gives an indication of a lack of confidence in their systems. So I think we have to think it through, that particular clause, carefully, because if I'm a bank, I will say, all right, I will send you by snail mail this notification. And you might get it in our terms, you might get it in 6 months.
So, Chair, the member is correct that the legislation doesn't prescribe how it is that this notification ought to be made. And I'm just wondering whether or not we would want to be very prescriptive in the legislation as to how the particular data subject ought to be notified. Currently in the scheme, the data controller has 2 obligations: to notify the commissioner about the breach, and then to notify the data subject about the breach. Unless it is that we are of the view, and I don't, well, personally I don't like those words about adding any kind of expeditious notification. Again, you basically impose something that is difficult to determine or to assess whether or not the data controller would have complied with notification in an expeditious manner. The word undue delay, again, is stated there. And if we...
My concern is less about the timing and more about the methodology, and whether, in thinking through the objective of 5, which is to ensure the subject is aware, whether the owner should be on the entity, or whether the commissioner, once it's reported to the commissioner, then has that responsibility. My concern really is that entities, unless they are forced, will not comply with this, or will find a way to circumvent it by using some means which effectively won't have the subject be notified in a timely manner.
I think it's worth noting as well that it appears to me that the only offense created by this clause is the breach of subsection 1, and that a breach of 3 or 5 is not a criminal offense. So I'm not sure what the sanction is for non-compliance with it, and I'm not, with the way it's worded, I'm not surprised it hasn't been made a criminal offense, for the very reasons we were already highlighting, that the imprecise language used in the concept of undue delay doesn't lend itself to being made something that can result in criminal liability.
What did your research point to in terms of other jurisdictions on this specific issue?
I don't recall that when we were doing our research and looking at this, that there was any specific Thank you. Any specific way of notifying essentially the data subject. However, CPC did share a while ago a particular formulation that perhaps could work, where it is that we could prescribe the form, manner, and time within which a data subject ought properly to be notified, essentially where there has been a security breach. So that is something that could be prescribed in the legislation if that would answer and address the concern. I just wanted to point out one thing though, because I think I understood the member to be suggesting that the notification to the data subject was not mandatory. And the way the legislation is stipulated, if the breach is likely to affect the subject, then the data controller has no choice. The data controller shall notify the subject essentially.
No, it's mandatory, but there's no sanction for breaching it.
Okay.
Yeah. And it's certainly not made a criminal offense. At least I haven't seen that in the section. In fact, subsection 7 is somewhat misleading, because it really ought to be clear as to where the offense is. And the offense is really in subsection 2, which is subsection 2 essentially makes breach of subsection 1 an offense.
But if we look at clause 21(2), and I'm going to say part B, a data controller who processes data in contravention both of the standards and any provisions of this part commits an offense and shall be liable upon both summary conviction in a parish court as well as conviction and indictment in a circuit court.
Well, it's to do with processing personal data and not doing it in compliance with the part. It's not failing to report or failing to notify.
Right. No, the way it is, well, the way we certainly read it is that it's disjunctive. It's who processes data in contravention of the standards, or, well, it's still in fact a processing in contravention of this part.
Processing personal data in contravention of any of the provisions relates to how you process the data. I don't think it could be construed as failing to report to the commission a breach or failing to notify somebody that there has been a breach. If you want to make that a criminal offense, you have to do it very clearly, and it certainly isn't done presently in a clear way. And I don't personally, it's not very, you don't say how the person is to be notified. How are you going to enforce, how are you going to charge and try somebody for breach of subsection 5 when you don't have any rules about how they're to be notified?
All right, members, for clause 21, subsection 2B, subsection 3, addition, there are changes there. Can you read exactly what that should say?
Clause 21(3). With respect to that clause, Chair, I believe the recommendation is that we remove the without undue delay and leave the time period of not later than 72 hours.
Okay, let me put that to the members. Okay. No objection to that.
Though, but if you're going to make that, if you're going to attach a penal sanction to that, surely it has to be within 72 hours of it of them becoming aware of the breach, or where they ought to have been. Is that there?
Member Golden, you can assume that it would be competently drafted.
All right.
I always assume that, but I think drafting instructions are always useful to the drafter.
All right. Okay, so no objection to clause 21(3) in terms of having a specified time in which the data controller shall report to the commissioner any contravention, any security breaches, and so on. With regards to 3,
clause 21(5).
21(5), you take out undue delay to 72 hours.
Yes.
Yeah?
Yes, for consistency.
For consistency.
That's correct.
Right.
But I also
But
thought...
we also need to come back in terms of how.
How
the data
you
subject should be
notify,
notified.
Well, I think the recommendation, Chair, through you to the members of the committee was that we actually have it prescribed, that the form, manner, and time within which, well, the form and manner certainly would be prescribed. So that is a recommendation.
Right. So we accept that recommendation that the format and time be prescribed. For
Five, yeah.
Okay. All right, so we will
Chair, just before we
make
move on,
those
the
adjustments.
Just before we move on, the recommendation, well, the concern that was raised by the member with respect to whether or not the breach of Section 5 is subject to Clause 21, Subsection 2, just to determine whether, and I agree with the member that the way it is currently drafted, it would not take into consideration 21.5. So the question is whether or not the committee is minded to make that failure subject to criminal offense.
21.5? Yeah, I think this should be. Of all the things that we have considered, this is probably one of the most serious breaches. And if you think of all the examples worldwide, most of these entities only acknowledge when they're forced. And you have had some of the big companies face humongous fines because of their reluctance to do this. So this is one where if there isn't, if it's just a slap on the wrist, a big company that has the capacity to absorb a monetary fine will just continue to defy the law. So I do believe this one would require it.
And the question also arises, should there be a statutory right of compensation given to the data subjects who may have suffered loss, distress, damage to their image and reputation, whatever it may be, as a result of this breach? Should the law not give them some right to be compensated without having to rely on the common law, some contractual right that they may or may not have, depending on the fine print of some terms and conditions of engagement or whatever? Just give them if you're going to penalize it, I think it should come with although I believe there is a provision that now allows courts to do that in certain circumstances anyway, where somebody's been convicted of an offense, but I don't know if it would extend to this, and I think we should specifically address it, because this is where the citizen is directly impacted.
Through you, Chair, perhaps Clause 71 could address the concern that was raised by the member. The clause stipulates an individual who suffers damage by reason of any contravention by a data controller of any of the requirements of this act is entitled to compensation from the controller, for that damage. And then it goes on to speak about the individual who suffers distress by reason of the contravention by a data controller is entitled to compensation.
So with regards to Clause 21, there's still the question of the notification to be included, right?
As well as to make failures to do so an offense, as well, Chair.
Right.
And through you. Through you, Chair, to the would the committee be minded to repeat the construct in 21.2?
21.2.
In terms of the structure.
Right, so 3, we're talking about
breach of 21 of clause 21 subsection 5 would be an offense, and the construct would be similar to what obtains currently in 21.2.
Right, which I thought what I'd heard was the 72 hours. But the question of how should the notification be done was still not answered.
Yeah, I mean, 72 hours is a reasonable period of time for some form of electronic notification, you know, but for actual other forms of delivering a notice, it may not be practical. So depending on where the data subjects are, how many there are, you know, all that sort of thing. So I think that if this is going to be made a criminal offense, there needs to be some prescribed methodology for how the notice is given, which would be and then if that isn't complied with within the time frame set, then that would be an offense. At least there's a provision that ensures a right of compensation for those who are impacted, which I think is the most important thing, really.
Okay. Ms. Newton.
So, Chair, for the committee, the recommendation is that the 21(2) A and B, that the construct there in terms of the offense be replicated for a breach of clause 21, subsection 5.
I think you were listening to the last point. No objection to that being the way in which it's punished, but you're going to need to prescribe how the notice is to be given and the time frame within which it must be given.
But I think we had said, my apologies, member.
In five.
Yes, yeah. I agree. I said my apologies was in relation to not answering the specific question. I'm so sorry.
Yes.
I believe that the recommendation was to remove undue delay and stipulate a time period of 72 hours in that section as well, in that clause as well.
Right, the 72 hours
reasonable.
is there, but still you had to, we have to answer the question of how will the data subject be notified, given that we're making this a criminal offense.
If you're going to criminalize it and have a 72-hour deadline, there has to be they must provide for notice being given in a way that can practically be delivered within that period.
And earlier we had recommended in response that we would prescribe the form and the manner as well. That was also a recommendation to go along with clause 21(5) that we'd have to prescribe.
Well, if you're going to do that, I think you should prescribe the time as well, because when you work out the form and manner, it may impact on what's a reasonable time. To go put a specific thing, I mean, you could just say here, shall within the prescribed, in the prescribed form and manner, or within the prescribed time and in the prescribed manner, notify. And failure to do that is a criminal offense.
We clear?
Much simpler in the case of the commissioner, because you can, it's just sending an email or something, and you can just say 72 hours is a reasonable outside time for doing that. When you talk about notifying data subjects, you know, the nuances of that may vary dramatically. So you're going to need to think through a notification regime that covers the different forms of nuances and a relevant or an appropriate time frame for each of those. So I think all of that should be prescribed, and if you breach that, then it's a criminal offense.
So through you, Chair, the recommendation then appears to be that with respect to 5, that what would be prescribed, we would be removing the 72 hours that was recommended, and what would be prescribed would be both the form, the manner, and the time of notification. So that all 3 would be prescribed. So we'd remove the 72 hours that we recommended, including here, and just indicate that both the form, the manner, and the time would be something that would be prescribed.
Yes. All right, so we would want you to come back with clause 21, subsection 5, in terms of the word in there, or are you good? Are we good?
I believe the
Just saying
CPC will
form,
draft.
manner? Okay.
We'll do the drafting, Chair. And
okay, all right. So we'll, to the committee, we'll accept clause 21, subject to the modifications as agreed. Approved, no objection. Yeah, well, I'm referring to all the modifications, right? subclause, well, 3, 5, those clauses, those subsections. All right. Let's move on to the first standard in clause
Chair,
22.
if I may, I know we're rushing to the first standard. I just wanted to raise one other concern that would have been raised by another stakeholder. This is in clause 21.5. We're still on 21.5. And the concern in clause 21.5, the standard that is replicated here stipulates that the contravention or the breach is likely to affect a data subject. And the concern that was raised was that the word likely imposed an unnecessarily low threshold and an unreasonable obligation on the data controller, and that the consideration should be given to wording reflected in legislation such as in Canada, where the words which were used were real risk real risk of significant harm to the data subjects, and not a threshold of likely to affect the data subject.
Real risk of significant harm, was that the formulation they were proposing?
Sorry, it would be real risk of significant harm.
And that's a Canadian formulation for
Correct.
this?
It's in the province of Alberta, which is what the stakeholder would have recommended in their comments.
So this idea of likely to affect, where did this come from?
My apologies. This has been reflected in the UK formulation at the time.
Which is more current, the Canadian or the UK? Because the Canadian would have been aware of what the UK had done.
The Canadian would be more
current?
More current, yes. That's 2003.
The thing is, again, if you're using these words, real risk of, they're so subjective. But likely is also, but in terms of criminalizing the conduct I'm talking about, I don't mind the formulation, Chair, and the fact that the Canadians adopted it after the UK. They would have been aware of what the UK formulation was. Maybe they felt this was an improvement. And the stakeholder who submitted the proposal obviously has a concern about likely to affect is a very low threshold, because as opposed to real risk of significant harm. It's less protection of the data subject to change to this formulation, but it's more, perhaps it's a more appropriate formulation, balancing the interests of both the data controller and the data subject. Because if there's no real risk of significant harm, then why criminalize the conduct?
Chair, so I believe that I understood the members to be saying that we could delete the use of the word likely and replace with the terminology used in the Alberta legislation, which refers to real risk of significant harm. Okay.
All right, I want to put that to the members. If there are no objections, we'll move on to clause 22, the first standard.
Chair, really, I'm sorry. I'm still on clause 21. So we're on 21.7 actually, because again, one of the stakeholders in looking at the terminology which is used in the legislation raised concern as to the language or the standard of proof used with respect to the defense. So clause 21.7 indicates that it shall be a defense for a person charged with an offense under this section to show that the person exercised all due diligence to prevent the commission of the offense, and the standard is on a balance of probabilities. The recommendation is that the standard of proof, notwithstanding the same, that the clause should be amended to read that the person exercised all reasonable diligence. I think the concern being raised that all due diligence there places a standard which is inconsistent with the standard of balance of probabilities. That's a concern that was raised. It's not a recommendation that there's an inconsistency, so we're not recommending a change, but I thought it best to bring it to the committee's attention for its consideration.
Okay. Ministry is not recommending a change to what's there in clause 21.7. And again, I put clause 21 to the committee with the various amendments as was previously discussed.
Sorry, Chair, I still have a difficulty with this addition of an offense for the failure to serve a notice, because I still think that it's covered by 2, and now what we're going to have is a real duplication, because the way processing of data is defined, or process is defined, it would be impossible for the data controller to not issue the notice and be considered to not be processing data, because processing includes just the mere fact that you have information stored. So it would have been an offense for the person, once there are a data controller, to have had a data breach and not had a security breach, and not given the requisite notice under the provision. So what happens now when a person, the data controller, doesn't serve the notice? They are then charged under this new provision about them failing to give the notice, and then they're again liable to be charged under 2 for not complying, for processing while not in compliance with this section. It's a duplication.
I don't see my way to agreeing with that, because in 2, a data controller who processes personal data in contravention of any of the provisions of this part commits an offense. And I don't think you could argue successfully that failing to give a notice in breach of a provision that requires a notice to be given to data subjects where there has been non-compliance, a security breach, that falls within the language of subsection 2. No matter how wide you define processing. Chair, I have to be excused for a little while. I'm going to try and come back, but I have to be excused.
Chair, I would be more comfortable in including a specific reference to failure to serve under subsection 3 or 5 in the actual existing offense under 2. Especially, it wouldn't matter since it's the same penalty. But I'm uncomfortable having 2 separate provisions that a person could possibly be charged under for the same set of facts. Yes.
Okay. All right, I put it to the committee members again. Clause 21 with the amendments as recommended. If there are no objections, we will accept clause 21 with the amendments. The amendments would be 3, a data. Oh, you want to go ahead? You want to go
Just to clarify that the amendment that I'm proposing to 2 then would be just to include the words after or any of the provisions of this part, the words or fails to serve a notice as required under subsection 3 or 5. instead of having a separate penalty provision.
Need another approval? All right. You've heard the refinement of that. Again, I put clause 21 to the members with the various amendments in subsection 3, subsection 5, subsection 7. All right, 2, 3, 5, and 7. All right, so we have to go. 2 o'clock. Members, in light of a reduction in the quorum to below what we have to have, we will end this session, and for the next session we will continue at clause 22, looking at the first of the 8 standards in this bill. Okay, the date of the next meeting will be next Thursday at 10 a.m. as well. $10 a.m., no? Next Thursday? Sorry. There's PAC at 10, and there's another meeting scheduled at 2 on Wednesday. So we have to take the days. Yeah. Thursday. Yeah, it was already scheduled. Thursday at 10. 10 to 2. All right. Thank you. All right, thank you, members. Thank you, members. The meeting is adjourned.